Here is your lordship. I recommend site number 4, my lord, on today's list, my lord.
On the prayer for, when was it last done?
My lord.
B.K. Mahajan's case. What has happened to him?
He's not well, my lord.
He's not well.
It's
What is this matter about?
It's 302, my lord.
Okay, on the prayer for adjournment made on behalf of Mr. B.K. Mahajan, counsel for the appellant, which is not objected to by Miss A. Begum. This is the matter.
Any day, my lord,
After a week.
after a week, my lord.
Please,
Obviously.
Your Lordship, I beg to mention item number 9.
Yes, what about it?
Lordship, Mr. Kial is out of station, Lordship. For an urgent matter, he has moved to Shillong, Lordship.
Okay, right. Adjournment prayer has been made on behalf of Mr. S. C. Kal, learned counsel for the appellant. On the ground that he is out of station. This is the matter after a week.
May it please, Your
Matter.
Lordship. Lordship, I beg to mention item number 2, my lord.
Yes,
Kindly adjourn the matter for a week, my lord.
adjournment prayer has been made on behalf of Mr. H.R. Chaudhary,
H.R. Chaudhary.
learned counsel for the appellant, which is not objected to by Ms. A. Begum, and it should be. The matter is accordingly adjourned for a week.
Keep your. May I please, Your Lordship, I beg to mention item number 3, Lordship. May I pray for adjourn the matter for a week.
Okay, right. Adjournment prayer has been made on behalf of Mr.
S.H. Raman.
S.H. Raman, learned counsel for the appellant. Any objection? No objection, as there is no objection from the additional people.
May I pray for
After the
fixed date, Lordship, 14 if.
Yeah, no, you're not bothered. This is the matter after that. Okay.
Obvious.
Daily list for orders, item 1.
So there was a negligence on the part of the. And it was, he was operated in month of June. Again, he,
Now, supposing we decide this appeal,
yes, my lord.
hypothetical question.
Yes.
Supposing we decide to uphold the judgment, then what happens?
Then also, then necessarily what treatment has to be given, my lord.
Treatment will be given.
But because that treatment is not available at Morigaon, my lord.
So now basically what you want is treatment should be given only. That's
Yes,
it.
that is basically.
Nothing else.
Nothing else. And more, your lordship was once rejected the application, my lord.
Okay.
And on the ground that this is the second time we have come back on. Who have the application, my lord? In the IA, my lord.
Suffering from
Now only one. Now what has happened? One important part, that is a question of hearing, my lord. One medical evidence is totally inconsistent with the ocular version.
No, you want to hear the matter, you want to hear the matter, we're ready. If
Because
you
that-
want to hear,
Because there are other appellants who are not before us.
where is the other appeal?
Mr. M. Bora APS, my lord. So if matter may be leaked for it, in the meantime, proper treatment may be given to him. That order, your lordship can pass the order.
We are ready for the hearing.
So he is not ready.
No, I am ready, but the other Mr.
Yeah.
Bora has to be ready. That is a difficulty.
So paper book is made, correct? And paper book is ready. Now
No.
IA is by,
I two of the appellates, that is.
it's not two of the appellant. So,
Nabi Hussain and Karamat Ali. This Nabi Hussain is suffering, my lord. He has been undergone second operation, my lord, recently, my lord. Fistula, my lord. Early in the month of January, he was done. Again in month of June, my lord, he was undergone.
so it has landed up before me again. So we'll reject it again, and if you give them treatment, what remains?
Yeah, then
What is the new thing? There's nothing new.
new ground has been medical evidence, my lord. That's inconsistent because according to the prosecution witnesses, my lord, all these more than 7 appellants, they came together with a hard wooden staff and assaulted the deceased. This is about 70, 80 years, my lord. There was no injury, my lord.
New ground.
No.
But that gun was not taken earlier, my lord. Earlier, your lordship has come to a finding that the evidence of witnesses are corroborated each other. So there's nothing to disbelieve them, my lord. Now the medical evidence that has come, my lord, there was no external injury, my lord. So far that disease is concerned, my lord. If a would,
Anyway, right. But Mr.
Speak up again.
Where is his name? That's what I'm looking at. In the IA, your name is only Miss Zia's name is here.
Jia is my.
Jia is there.
No, but who are you?
I also have.
Where is the Wakalat?
Wakala is the main appeal, my.
It's in the main appeal.
Is it there in the bill? Second one, my lord.
Okay. I was thinking maybe he engaged you.
Yes,
Huh? Okay, anyway, right. Third, Mr. P. Kataki. Learned counsel for the applicant. And Ms. B. Bain. Learned additional people. This is an application under section 430 BNS for suspension of the sentence and to release the applicants, that is the appellants number 2 and the appellant number 3 on bail during pendency of the applicants counsel submit that the reason for praying for suspension of the sentence is due to the fact that the what?
Mainly on merit, my lord, that the prosecution evidence, the ocular version doesn't support the medical evidence. That is the 1% that your lordship is.
That has already been.
That was appreciation of evidence, my lord. Another is the ground of this Navi Hussain, my lord. Fistula, he has been suffering, proper treatment has not been
Okay,
given.
on the ground that the ocular evidence
That-
is not supported by,
It doesn't corroborate the
does not,
medical evidence.
it does not, is not corroborate, is not,
Totally inconsistent, my lord.
is inconsistent vis-a-vis the medical evidence.
Evidence.
He also submits that in respect of the applicant number
One.
1, who is the appellant number 2 in the appeal. The applicant number 1 suffers from fistula.
Fistula.
How do you spell that?
Fistula. That I report I have enclosed, my lord, your lordship.
And he was accordingly
And he was operated on 8/1/2025.
upon on 8/1 2020
2025, my.
2025. However, the said applicant number 1 needs further
Post-operative
post-operative treatment.
was not given to him, my.
Needs post-operative treatment and the same was not given to him. He accordingly praised that for medical reasons, the applicant number 1 should be granted.
In fact, there was a relapse of the same fistula again in month of June, my lord.
But it is not on record.
That is not on record, but we have mentioned in paragraph 1, my. Again, review.
Okay, he further submits there was a relapse of fistula on the applicant number 1 in June 2020.
June 25.
Anyway, he also submits that the earlier application made by the applicant of suspending the sentence made under section 389 CRP had been rejected by this court earlier on 8/1/2024. Ms. B. Buyan, the learned additional PP submits that the earlier application for suspension of sentence has been rejected on the ground that the evidence of all the witnesses appeared to be in tandem with each other. And as such, there was no ground for suspending the sentence. With respect to the applicant number 1, Nabi Hussain, the additional PP subjects that required medical treatment would be provided. What?
Without instruction, maybe he's getting it, my lord.
Would be provided
Maybe getting.
If not provided
Your
to
is
him,
okay.
if not provided to him.
Isn't that?
Naturally, you have to say that you cannot,
Well,
we cannot provide. You have
No,
to
no,
say
he,
that.
they might have providing him.
That's why if not provided to him. Yes. We have heard the learned causes for the problem. It is seen that the applicants and their co-accused had earlier submitted, and their co-convicts had earlier submitted IA Criminal 657 of 2023, praying for suspending the sentence for the impugned judgment dated 31/5/23, passed by the court of the additional sessions judge number 3, Nagaon, in sessions bracket T-1 bracket close, case number 47 bracket N/2015, by which the applicants had been convicted under section 305 and sentenced to undergo life imprisonment with a fine of rupees 5,000 each, and in default to undergo rigorous imprisonment for one. This court had rejected the earlier application of the applicant by order dated 8/1/2020, by holding that the testimonies of the accused witnesses appeared to be in tandem with each other. And that's how it did not find any ground to suspend the sentence. In the present case also, we do not find any ground to suspend the sentence. However, in view of the applicant number 1 requiring medical treatment, the jail authorities are directed to ensure that the required medical treatment is provided to the respondent number 1, if not already provided. The application is accordingly rejected. It is accordingly disposed of by rejecting the application for suspending the thing. Then in the main case, as paper book has been prepared, list the matter for hearing. When do you want?
Today is September, man.
September? You want treatment in jail?
Statement, my lord, because Bora is there, my lord. He is not before.
Yeah, list the matter after 4 weeks.
May I please, Lordship? Lordship, this is our second application for suspension of sentence. Lordship, may I summarize the actual and legal aspect of this IA?
Lordship, paper book is ready in this case also, Lordship. It is a NDPS, Lordship.
Lordship, yes.
So,
So I
Lordship,
may be given 5 minutes.
Maybe
Lordship.
hearing, fixed for hearing, Lordship.
No, anyway, then let us see. This is the Ganja case,
Lordship,
20B2C.
Lordship.
Lordship, I may be I may be given Lordship 5 minutes.
Okay, we'll give 5 minutes. What is it?
Yes,
Lordship.
Lordship, the textual and legal aspect of this IA.
3 accused.
Lordship, there is 3 accused. I am appearing for 2, and another accused filed a separate IA, that is 219. Lordship, the factual aspect is there, Lordship. Both 3 accused has been convicted.
Both 3 accused.
Sorry, Lordship. All 3 accused have been convicted in March 23. Thereafter, I have filed for 2 convicted person for appeal, and the another one filed a separate appeal. In September 2023, our first IA was dismissed by this honorable court for suspension of sentence. Subsequently, in the next month, October 23, the IA filed by the another accused also dismissed by this honorable court. Then the single accused, convicted one, he approached our honorable apex court. Later, apex court granted him interim relief, lordship. And so, lordship, our IA has been now filed for parity relief, lordship. And I have annexed the apex court order, lordship, at page 14, lordship. Kindly see, lordship, kindly. I am not hurry for the hearing of the appeal at this time, lordship.
But we are in a hurry to do.
Lordship, our present IM may be decided, lordship, on merit, lordship, or inch of justice, lordship.
The ends of justice would be
Yes,
met
lordship.
if everything is decided.
Yes, lordship.
Why
Lordship,
part-
kindly see the page 14 of apex court order, lordship. Page 14, lordship.
You don't have any other ground than this Supreme Court.
Other ground, lordship. There is other ground is, lordship, the appellant number,
It was earlier rejected, correct?
lordship.
Then your IA was earlier rejected first.
Lordship, I
Your
could.
IA, one of the IA was earlier rejected.
Yes, lordship, yes. And it was rejected in September
One
2023.
of the co-accused went to the apex court and
Yes.
he got an interim relief.
Yes,
You
lordship.
you want to
Yes,
have.
lordship,
interim
I want the parity relief or interim relief, lordship.
Okay, you come to page 12.
Page, lordship, 12, lordship.
Read the second sentence.
Second para, lordship.
Sentence.
It is obvious that criminal appeal of the year 23 is not be likely to be heard in the near future. Moreover, antecedents of the appellant have not been brought on record.
So,
Same, lordship. Yes.
we are ready to hear it today.
Lordship, I am not ready for the hearing of the
No,
entire.
you
appeal,
see,
lordship.
Yes. The Supreme Court has granted bail
Yes, lordship.
on the ground that the criminal appeal of the year 2023 is not likely to be heard in the near future.
Yes, lordship.
But today,
Yes.
we are saying to you, we are ready to hear you today.
Lordship, lordship.
So the reason for the bail granted to the other person
Yes, lordship.
by the Supreme Court
By order dated
in May
yes.
will not be applicable now because we are ready to hear you now. Right now we are ready to hear. Right now.
Lordship, today I am prepared. for-
Tomorrow?
I only, lordship.
Tomorrow?
Lordship. My humble submission is there.
Monday? Tuesday?
Lordship, I may be given 2 minutes, lordship. Lordship, what happened if this honorable court hear the entire appeal and suppose
We have to hear it one day.
Lordship, yes, lordship. And suppose the conviction is upheld by this court.
Correct.
Then, lordship, what happened? In my case, appellant number 1, when he was arrested in February 2022, after immediately of his arrest, his first child born, lordship, daughter. Lordship, it is a emotional aspect of that matter. But lordship, and he is also suffering from. I have mentioned in my statement, lordship.
Look, he's suffering from this, he's suffering
He has
from
been
that.
treated by the jail authority. It is
He's,
also true, lordship.
he might be having the most important job in the world.
Lordship.
We are ready to dispose of your writ appeal. I mean, this appeal, your criminal appeal. You don't want to dispose.
Lordship, yes, lordship.
But you want bail.
But
But you
lordship,
got a bad case.
lordship, I humbly pray to first decide my IA on merit, lordship, inch of justice, lordship.
How can, you see, when we are ready to dispose of your case, we are ready. I'm
But
telling
not
20B2C is not very hard. You have got to, there are certain provisions of the NDPS Act which
Yes.
has to be followed. If not followed, then you've got a good case, you might have a good case. How do you?
Lordship, today I was prepared for the IA only, lordship.
Unfortunately, the reasoning given by the Supreme Court
Yes, sir.
does not hold good as on date because we are ready to hear you today. I will say, but we are rejecting your application and we are going to record also that we are ready to hear you today, not the council is not ready. When any day this week is not ready, we are, and then we'll fix it for next week. We'll fix it for hearing next week. Wednesday, we'll decide everything.
Lordship, I am able to. So Lordship is then
Huh?
Lordship, then it may be hard. Then Lordship, then my IA should be
We're rejecting, we're rejecting, we're rejecting. The reasoning, you see, the parity of the benefit,
yes, Lordship.
that will not apply now, because we're ready, and paper book is here. So what remains? We'll list
Then Lordship,
it next week, we'll list it next week, we'll give reasons why we're rejecting. And we'll list it next week and we'll hear you. How do you know? Instead of bail, you might get acquittal also.
it is true, Lordship. But I was fully prepared for the IA today, and
Then you are prepared for the acquittal also. Prepared for the entire case.
We have already heard you only what about you?
yeah, Lordship. Lordship, my last submission that if possible, Lordship, IA may be decided, Lordship.
We're deciding, we're deciding. It's okay. We accede to your prayer, we're deciding.
Yes, Lordship, IA may be decided on merit, Lordship. It is my
We're
satisfaction.
we're deciding as per the Supreme Court decision. On the reasoning given by the Supreme Court, we're deciding. Heard. Mr.
M. Pathak.
M. Pathak, Learned Counsel for the applicants. Appellant. Also heard Miss A. Begum, additional people. Right. The case of the applicants, along with another convict, namely, what is his name?
I am representing to Bipin Kumar and Bira Mahat.
We're not,
Suraj Kumar.
Suraj Kumar are representing by them.
Suraj Kumar
Roy.
Roy. Suraj Kumar Roy. Is that they were convicted under section 20B2C
Yes, Lordship.
of the NDPS Act, while judgment and order dated 9/3/23 passed by the learned special judge Bongaigaon in special bracket NAR bracket close case number 23 bracket BGN bracket close of 2022 and sentenced to undergo RI for 15 years with a fine of rupees 1 lakh each, in default SI for 6 months. Next part. The applicants had, besides filing the present appeals, they had also filed an application under section 430 BNSS,
Yes, Lordship.
suspension of the sentence imposed by the learned tribe. The said application had however been rejected
Yes, on 26/9/23.
on 26/9/23 for all the three.
No, only my two convict. His was rejected in October 23.
Okay, on 20. What have I said? This last sentence. No, just before that. So, application. By this court. The application under section 430 BNS that had been filed by Suraj Kumar Roy had also been rejected by order dated Suraj Kumar Roy,
Suraj Kumar Roy was October, যেটাতে আছে যাবেন এই সুরজ কুমার রয় order is in October 23 তা মুখ দিয়ে সুরজ কুমার রয় 5th of October 23
5/10/23. Please call. Mr. The Suraj Kumar Roy thereafter approached the Supreme Court by criminal appeal number 2642 of 2025. The same was disposed of by the Honorable Supreme Court by order dated
16 May 25
16 May 25 by granting bail to Suraj Kumar Roy on the ground that the criminal appeal that had been filed by the appellant Suraj Kumar Roy was not likely to be heard in the near future. And due to the fact that the antecedents of Suraj Kumar Roy had not been brought on paper. Next fact. The counsel for the applicant submits that the applicant's hearing should be granted. What parity?
Lordship, on parity,
Parity, what parity?
on parity because my
Parity, what parity, what parity of what? Parity, this is in the parity in the relief granted.
Yes, Lordship. Lordship, 1 minute, Lordship. I have a apex court judgment of old apex court judgment of constitutional bench on parity, Lordship. Lordship, kindly give me 1 minute to. May I read the,
You all will never come for the appeal hearing. Once you are granted bail.
may I read the relevant para, Lordship, para 6, Lordship.
How much was seized anyway?
Lordship, total quantity. It was 20 kg, but there is a
20
twist, Lordship,
kg, 20
20 kg. My two convict was in a same train, but in sleeper coach, and Suraj was in AC coach. They are arrested separately, but their quantity is clubbed, and they are punished for commercial quantity. That is the twist in the case, Lordship.
For you, 20 kg.
Yes,
Kumar Roy?
all three are in 20 kg, but from me, it is, recovery was done for 10 kg, and from Suraj 10 kg, but it was clubbed, and it was made commercial quantity, and we have been punished for commercial quantity. There is some twist which we will hear in the appeal, Lordship.
And you all bought the train ticket with the same PNR number?
No, we have been arrested from sleeper coach. Suraj have been arrested from AC coach, from same train.
Different ticket. Different train ticket. Train tickets was different.
Yes, Lordship.
Different.
Train tickets were different.
Do you have the train tickets?
No,
That was not part of
Train ticket.
the document. Huh?
no, Lordship.
Or were you a ticketless traveler?
No, Lordship. We had the ticket.
Huh? Where is the ticket?
We had the ticket. I think.
Where is the ticket?
Uh,
Is it part of the record? Was it seized by the police?
yes, Lordship.
The tickets were seized.
Police did not seize the ticket, but they mentioned the ticket number.
Did
Yeah.
they mention the PNR number?
They mentioned in the FIR, Lordship, about the arrest from the sleeper coach.
You're not getting what I'm trying to say. You see, one thing is that whether two persons work in tandem,
Yes,
work together,
yes,
or they work separately, can be known if the ticket, it can, an implication can be there.
yes.
If the ticket is bought under one PNR number,
Oh, PNR.
like you buy, supposing you and your family
Ah,
are going to Delhi from here, You buy
Yes,
for everyone in one ticket.
yes.
Everything.
That means 4 person may get the
One PNR number,
one
different,
PNR,
have
yes,
different seat numbers.
No, PNO number is separate, Lordship.
How do you say that?
No,
Lordship, this IA should be go to the same bench, Lordship, as it was earlier rejected by another bench, Lordship. Coordinate bench. Bipin Kumar and
yeah.
Meera Mahato. Earlier rejected by
Rejected by?
Justice K. Surana.
Justice Honorable Justice Surana sir, Surana and
If you go to
Midul
the
Kolita,
appropriate
Honorable
bench,
Justice.
Acha, Suraj's case was rejected by whom?
Lordship,
Huh? By me. And Justice Nandi.
No, Mitali and Justice Mitali and Mayor Lordship.
Oh, Justice Nandi. And but this one is by somebody else.
Lordship, Honorable Justice K. R. Surana.
But then
Suraj Kumar Rao.
we'll fix the entire thing for hearing.
Hearing.
We'll dispose it off. It's only 20.
সেটু পার্ট অফ মই এতিয়া বলে দিগদার হ'ব
What have I said? To be granted the to be granted parity of the benefit provided by the Supreme Court to Suraj Kumar Roy. Next paragraph. The additional PP on the other hand, subject that as the application for suspension of sentence of the present applicant had earlier been disposed of, has been rejected
yes
by the division bench of Justice K.R. Surana,
yes Lord.
Honorable Justice K.R. Surana and Justice
Midul Kolita
Midul Kalita.
Middle Kumar.
The present application would have to be heard by the same bench in terms of the notifications issued by the High Court. Correct? Then what to do?
Lordship, short date may be given, Lordship.
First up, on considering all the above aspects and keeping in view the fact that the paper book has been prepared, besides the fact that this bench is ready to hear the entire matter, even today, this court is of the view that the matter should be heard expeditiously. The applicant's counsel submits that the matter may not be heard today as he is not prepared for the case. Accordingly, leaves this application along with the main appeal for hearing on when give a date. We decide.
15 hours.
Lordship, 14 going on, it's not 14 hours.
After.
No, they're in a hurry.
No, I am not in hurry for the appeal, Lordship. I am hurry for the IA, Lordship, to be honest, Lordship.
Then you go before the same bench.
Yeah.
Last of August, Lordship.
It's a small matter. You just have to see whether 52A has been complied with.
29th of August, Lordship. Friday.
Telling the matter, 29 August. Okay, then the councils, the councils for for Suraj Kumar, Mr.
Suraj Kumar, right? Mitra, yes, Mitra.
Mr. S. Mitra appearing for the for the appellant in criminal appeal 219 of 2022 is present. That's all. This is a matter of 29th August. We'll dispose it of. It's a small matter. How long have you been in jail?
3.5 years, Lordship.
And your friend?
All are same, arrested on same day.
We'll finish it off.
But my friend already released on bail. Now, my client are, imagine, Lordship, the situation.
No. You are not understanding.
Yes, Lordship.
Why don't you want it to do it fast? Your time matter. Why are you making him? How do you know? You might succeed in your appeal.
Lordship.
May I please, your lordships? Lordship, with the lordship, on account of some personal difficulty, my senior is unable to be present here today. So I pray before your lordships to kindly pass over the matter for the day.
Madam, this is a legal aid. He's a council, legal aid council.
Yes, lordship. Lordship may fix it up in the next week.
There's eyewitness also. Correct?
Yes,
Yes, yes.
He has already taken time to take it. Last time.
Yes, on the last two occasions.
lordship.
No, you see, earlier also, adjourned on the prayer P. Mahanta. Third P. Mahanta. What is this?
Lordship, last
I
time.
think we will change the amicus curiae. You know the way.
Lordship, grant us the last time.
We'll listen next week
Lordship,
and tell him that if he does not come, we are going to change it. We're going to put another amicus.
lordship.
Right. A request has been made for adjournment on behalf of Mr. P. Mahanta, learned amicus curiae. It is noticed that the present appeal has been adjourned on numerous occasions on the prayer made on behalf of Mr. P. Mahanta, learned amicus curiae. As a last chance, the matter is adjourned till, give a date, next week. Next week or maybe after just next week also no problem. That's fine. 13th, huh? It is made clear that if the amicus curiae that does not appear on the next date for hearing the matter, there is a likelihood of this court changing the amicus curiae of the case.
It please your lordship. I seek some accommodation in this.
What is this? Everyone seeks accommodation. Where is the Sadhu's wife? You've got the paper book, madam? Yes, you've got the paper.
Yes, Lord.
Come to page 22. Please read.
Page 22, Lordship.
Yes,
PW8
yes,
is that alleged eyewitness, Tipari Ghattuar.
correct.
And in somewhere her name has been shown as Tipari Ghattual. Exhibit 3 names her as Tipari Ghattual. Lordship, at page 22, I am the informant. Accused Dhan Gwala is my son-in-law. The incident took place 2 years ago. The incident took place at about 5 p.m. on a Monday. My son Motilal Ghattuar registered accused Dhan when he saw the accused beating the latter's children. The accused, taking a bothi dao in hand, rushed at Motilal, and after holding Motilal by the hair, he cut his neck with the bothi dao. His neck got severed from the body. He died instantly. The accused was under the influence of liquor at that time. I cried out, and soon the following day, the people caught the accused and took him to the police station. Then I lodged the complaint in the police station. The accused had run away after committing the incident. He was absconding for a period of 3 months, and thereafter the police nabbed him. At the time of occurrence, Motilal and I were at home. I put my thumb impression in the Ejahar. The police questioned me. In cross, the accused is my son-in-law. It was dark at that time. Motilal did not consume liquor. The incident took place in the courtyard of my house. At the time of occurrence, the daughter of the accused was 5 years old and son 4 years old. The accused was staying at our house as a soponia, living at the house of another as a dependent. The Ejahar was written as per my version. After hearing the hue and cry, the neighbors, namely Hemi Bhumij and Probin Kormokar, came. His head got separated from the body. It is not a fact that while making my statement before the police, I said that the head of my son had got separated. It is not a fact that the accused did not kill my son and that my son succumbed to the injuries he sustained in a fall under the influence of liquor. It is not a fact that neither I was present at the place of occurrence, at the time of occurrence, nor the accused inflicted cuts to my son.
He saw her son-in-law
Yes, Lord.
beheading her son. Well, so why can't we believe this witness? That's all. One eyewitness is enough. Imagine son-in-law beheading the son. Double, double whammy for her because her daughter's going to suffer also. That's all. There's nothing else besides this. The entire, I think this makes up for anything. There's only lacuna here will be maybe in one place he says that he was under the influence of liquor. And now they said Matilal did not consume liquor. Now who is Matilal? I don't know. Okay, Matilal is the son. So you see, he was under influence. That's it. What is there to decide? What is there? What are you going? How are you going to counter this?
Lordship, let me come back.
No, we'll do it together. We'll read from the very beginning. Let us go to PW1. Come. Let's go page 8.
Lordship, let me first take your lordship to the FIR.
Okay,
Date of occurrence is 20th March 2017, Monday at 6 p.m.
ah,
FIR was lodged on 20th March itself at 11:30, 5.5 hours later. Just to note, lordship, the distance between the place of occurrence and the informant's house is 12 kilometers.
distance between the,
And here, lordship, distance between the direction and distance from the police station is 12 kilometers northeast.
from the place of occurrence,
Yes, Lord.
12 kilometers.
Hmm.
12 kilometers between police outpost or station,
Station, PS.
police station and place of occurrence. So, and the incident occurred at what time? Around 6 p.m.
Around 6 p.m.
Now, have you tried walking at night? Have you tried walking at night in the villages with a torchlight? You cannot walk very far. Takes time. It's not like, I walk normally 5 kilometers in 1 hour. My normal walking time. Not fast, normal. It's okay. So 10 kilometers in 2 hours. 12 kilometers will be 2.5 hours. Now that is during light. At night, in the village where there is no light, with a torch light, you'll take some more time. Maybe another hour or so. 3.5 hours. So 5 hours is okay. That is one. Next.
Lordship will come to page 4. This FIR was actually written by a scribe
So, how does it matter?
where he was, and it all that has been written in the FIR has been put in the mouth of the scribe. That scribe has not been examined.
Who is the scribe? Where does it say? Where does it say written by scribe?
It's by her RTI is there, right hand thumb impression
So,
of Tipali.
so someone is written on. How
Yes,
does it matter?
Lordship.
Someone is written.
It matters because he has to be examined.
No, show me.
Non-examination of
How do you
material.
know that this lady cannot sign? Did not sign this or did not write this? Did you question her? Did you question her on this aspect in your cross-examination?
No, Lord.
Then how can you now bring up things without questioning her on that?
I have the honor to state that around 6 p.m. today on 23/17, Don Gwala killed his brother-in-law, Motilal Khatwar Sadhu, aged about 30 years, a resident of Bisnupur, Majgaon, by hacking him with a dao, taking advantage of the darkness, and then ran away immediately. I therefore pray to you to investigate the matter and take necessary action. Lordship will come to PW9, page 25.
PW9, page
Yes.
25.
Yes, the MO's evidence, Lordship.
Yes.
On 21/3/17, I was working at Bihali Police Station, PHC, sorry. On that day, I examined the dead body, Motilal Ghatwar, male, aged so-and-so, 30 years. The findings are as follows. Page 26, Lordship.
Yes.
One incised of size 2 into 1.5 inches over left lateral aspect of the neck at level of cervical 3 vertebra, exposing the laryngeal cartilage and cutting the trachea and left cervical vessel. No other external injuries found. stomach congested, no food matters found, smell of alcohol found. This is important, Lordship. All the injuries were of antemortem in nature. The time since death was,
Smell of alcohol found.
yes, Lordship.
You see, you see, the other
He was
day
drunk.
I was reading an article. These drivers who had jackfruit, they became drunk. They showed alcohol in their system because of the smell, or was it Tamil Nadu, no? The smell, or in their blood? It was the alcohol in the blood. That's how fermentation process took place. So it is there. So it depends on, you see, and another thing, if you look at the Supreme Court judgment, to see whether there is blood, there is alcohol in your system, you need to take you need to take out the blood by through a syringe and testing it. Not by smell. By smell, it might like some chemicals. They smell like alcohol, but they're not alcohol. They could be industrial alcohol also. And anyway, the smell of alcohol is different. Different alcohols are there.
Then Lordship will note that death was due to sudden arrest of cardiorespiratory system as a result of injuries sustained under influence of alcohol.
Okay, but was his neck, was his head still there or not? Or was it severed from the body?
And it's important to note that there was no inquest of the
No,
dead
no,
body,
please read that,
nor the
nothing, no,
offending weapon was.
Please read his cross-examination. Page 26.
Yes, Lordship. Such injuries may also be caused by falling with force on a sharp weapon like boti.
Okay,
So,
as sustained under the influence of alcohol. Are you sure this doctor is not under alcohol himself? Might be under the influence of alcohol. How? Let us see the post-mortem report. Where is that?
At page 50,
Huh?
Lordship page,
Page 58.
not 450, 50.
Very good. How can he say all this when he says that there is one incised 2.2 into 1.5 inches over at neck of cervical 3 vertebra, extensor, cutting trachea,
Lordship, at page 54, your Lordship will come. Opinion of the assistant surgeon as to the cause of death. The death was due to sudden arrest of cardiorespiratory system as a result of injuries sustained under the influence of alcohol.
Same. That was due to.
So what is the case you are trying to make out of that?
Lordship, at least this appellant is entitled to a acquittal. I think so, Lordship. That's what I could make out from the reading of the.
No, you see, doctor's evidence is anyway advisory in nature. It is not proof. It's only advisory. We don't have to follow the doctor's thing. Either we accept or we don't accept. Now, of course, but we'll have to look into this aspect. Madam, what is this? What kind of a doctor is he?
Lordship, it's only suggestive, your Lordship, when eyewitnesses account is there, Lordship,
Correct.
she's consistent, my lord. At base, she might have a case for single injury and Lordship subject to Lordship, whatever your Lordship observes, she might have a case under, which may come under the exception,
Yes,
my lord.
Exception for what?
Exception because due to grave and sudden provocation, it may
Section
be.
1 to section 2.
Yes.
Isn't it? That's what I'm trying to say. But is there anything to show?
But Lordship, Lordship may see the injury. His neck got severed from the body. Is it possible, Mala, as the doctor was saying, under the influence of liquor, he fell down and because of
You see,
boti,
that is the problem.
My
No,
lord.
no, you see, the problem is Witness said that severe from the body. But the doctor's report says one in size of size 2 into 1.5 inches over left lateral aspect of neck at level of cervical 3 vertebrae,
My lord.
exposing surfaces. So the inside the wound is 2 into 1.5 inches.
My lord.
So we are on this. For this, it cannot sever the entire head neck.
Lordship, may I see the vernacular portion?
Yes, this thing is.
Translated one.
I don't understand this, doctor. When the
Yes, sir.
when the mother-in-law has seen her son being killed, he neck got severe from the body.
ডিঙি তার এড়ায় যায় little bit.
Huh?
ডিঙি তার এড়ায় যায়. It was severe.
Who said?
The PW8.
No, PWD has said that. That is not an issue.
Tipari Ghattual.
But what is the doctor?
Oh, doctor. No, it's in English.
Okay, the same.
How could the doctor say that under the influence of liquor he fell down?
I don't know. That is what.
As the alcohol was found, maybe for that reason he has written like that.
He found alcohol in the.
Maybe while drinking, he mistakenly spilled some of it into the body, the cadaver.
And his opinion, such injury may also,
I don't know.
suggestive, your lordship, may also be caused by falling with for
Look, even if that person had drunk alcohol, how does it matter? Even if he smells of alcohol, the dead person, how does it matter? You see, because the thing that bothers us is that how could the doctor say that that the death was due to injuries sustained under influence of alcohol? What were the injuries sustained under influence of alcohol? How does he know?
But other witnesses say they saw cut mark in the neck of deceased.
No, this doctor, he's saying injuries sustained under influence of alcohol.
I know.
What are the injuries sustained under the influence of alcohol? This doctor, you tell doctor, how can you say injury sustained? I can understand if he says that the liver has gone for a 6 and he died due to cirrhosis or something like that. That can be injury sustained due to alcohol. And how does he know that the injuries were sustained under influence of alcohol? Under influence of alcohol on whose account? Is it because of his smelling of alcohol in the stomach, the deceased?
Yes, lordship.
Or because the other person was under the influence of alcohol? How does he know that he sustained injuries under the influence of alcohol? How will the doctor know that, supposing, say, Mr. A, is hit by Mr. B, and both of them are smelling of alcohol? Can the doctor who examines them the next day say that Mr. A is injuries due to influence of alcohol? It's influence of being hit by B, not influence of alcohol. How does he know that his injuries are due to influence of alcohol? How does he know that? It appears that this doctor himself is under the influence of alcohol. Doesn't know what he's writing. Next.
Let me come back, Lordship, after 2 weeks.
Why?
I'll,
There's nothing here. Supposing Mr. A dies. Say after drinking alcohol, he gets drunk, he falls into a lake and drowns. And the doctor examines him the next day. Can the doctor say that that person died due to influence of alcohol? He died due to drowning, not due to influence of alcohol. He died due to drowning. He can say that. Due to, how can he say due to influence of alcohol? What happened? He fell or what? How does he know what injuries were caused due to influence of alcohol? Totally unbelievable, this doctor. Must be one of these. Today I read in the papers that this fake doctor who had conducted 50 C-section surgeries, 50, mind you, 50, has been arrested. Fake doctor. Probably he's one of them. One such doctor. How does he know what happened to that person when he was drunk or while he was drinking liquor? He's never seen him in his life, only seen the dead body the next day and comes to that conclusion. He can say, yes, he's smelling of liquor, that's okay. But how can he say that he died due to influence of alcohol? What happened due to influence of alcohol? We don't know. How can doctor is useless?
and
Anything else?
Lordship, the offending weapon, bloodstained clothes, all these were not seized by the,
Okay, weapon and
yes, Lordship, that
weapon
important.
and clothes, not seized.
It's, it can be made out from PW 11 in this or Gogoi's evidence, Lordship.
PW 11.
30, page 30. Page 31, in cross, when the accused voluntarily appeared at the police station, I interrogated and then arrested him. I did not go searching for the accused. I did not seize any article in the course of investigation, nor the preceding IO seized the weapon used in the incident and the bloodstained cloth. It is not a fact
So
that
he voluntarily surrendered, is it?
Adayu PW 10, he says the injury on the esophagus as well as on the neck. Page 28. Accused is absconding, man.
Accused of absconding.
Yes, as per the evidence of PW 10, one of the IO, second officer got to yes.
After 3 months.
Yes.
Okay, he surrendered after 3 months. Where is the arrest memo?
No, it would be on the record, man. Get a bunch of thank you. Thank you.
No, but just tell me, the
yes,
mother-in-law of the deceased, I mean of the
accused.
mother of the deceased. Would she tell a lie? Is she going to gain anything?
He is an interested witness anyway.
What do you mean?
But-
Her daughter's husband is there. Huh? probably her grandchildren's father. How is she interested? Interested witness maybe in a way that son and thing, but then they are also witnesses.
But lordship,
Is there any
Are-
enmity between them? Is
Rela-
there any enmity?
relationship between a mother-in-law and a son-in,
Mother-in-law and son
son-in-law.
is usually very good. It probably the problem usually lies with the daughter-in-law and the mother-in-law. Usually, most of the problems, at least I have known in my experience, when talking to others and reading, happens between the mother-in-law and daughter-in-law. Son-in-law and mother-in-law are fine.
Arrest memo is of 19/1/18. Date of occurrence is 23/17.
Date of arrest
Lordship, may
is
kindly see.
arrested when?
Lordship, may kindly have a look.
Arrested. Arrest inspected
19/1/18, if I'm not wrong.
19/1/2018. My God.
Occurrence is 23/17.
That means after around 9 months. 9 months.
He was absconding.
Nearly 10 months. Absconding. And this and this doctor. What kind of a doctor is?
There are judgments, but it's just suggest statement.
I know. No, but then I mean, how can such a doctor
Hello.
give such a report?
Lordship. He's a senior medical and health officer.
Injuries sustained during injuries sustained under the influence of liquor. How does he know what happened to him?
Yes.
He fell against a knife
Hello.
or what? And how does that have, supposing a person is under the influence of liquor and sleeping, and one guy comes and chops him off? Can it be said that the injuries were sustained because he was under the influence of liquor? No, he was sleeping. He might be sleeping due to medicine, sleeping pills, might be sleeping due to liquor, might be sleeping because he's tired, might be sleeping for so many reasons. But the chopping of the neck is not because of those reasons, it's because somebody chopped it. That's all. Anything else?
Lordship, there are many hearsay witnesses here who have come before this court.
Hearsay, so we see, we need only one good witness.
PW2 is
Ah.
a hearsay witness.
So those we are not, you see,
Shiva Gaur, he was informed by one youth named Shiva Gaur. He has apparently not been examined. And from his statement at page 11, 10-11, we can make out that the Bothi dao was not seen. It was from the wife of the deceased that the accused had hacked her husband with a Bothi dao. He came to know. I was informed
you see,
of the incident.
when a person has run away, after killing somebody, he's run away with the weapon, he's run away with his clothes. He's not going to wear the same clothes for the next 9 months. He was caught only after, not even 9 months, after 10 months he was caught.
Again, PW3 is a hearsay witness. Offending was
Yes, sir. All of them are here. Only,
the
only
dao
that-
was not seized. Even he says,
Madam, please understand. How do you expect a dao to be seized when the person who used the dao had run away for 10 months?
Lordship, here is a case that has to be proved beyond reasonable doubt.
It is
Anything-
proved. Eyewitness is there.
We cannot.
Huh? Okay. That's anything? That's all? Anything else?
Lordship, let me come back otherwise next week.
No, madam, this is for hearing. All the cases, if you adjourn, we will have nothing to do. The reason why it's for hearing, it's that it's supposed to be heard today. Persons who wanted adjournment, we have given them adjournment because they had asked for it. They had submitted memos earlier, yesterday they had submitted application. Yes, madam.
Lordship, an eyewitness's account is there, my lord. The lordship will not go into the other evidences. When it is
No,
consistent,
I can understand.
my lord,
If say on the same date itself, the accused was caught
my lord,
and then weapons have to be seized.
my lord.
But they caught him after 10 months. So where's the question? Most probably he's thrown it away, hidden it.
And one of the witnesses says it was thrown away. It was thrown away somewhere in the field.
The paddy field,
My lord?
thrown away in the paddy field.
Yes.
Anything else?
PW7, Lordship, is
Yes.
Pablo.
Yes,
Before that, Lordship, PW6,
yes.
page 18, is Shyam Gwala. He is also a hearsay witness. Lordship, on cross, he says that he heard from Rina Ghatwar. It's at page 19. I was not at home at the time of occurrence. The place of occurrence is about 6 kilometers away from my house. I learnt about the incident from my aunt,
Correct.
wife of father's elder brother, and Rina Gwala.
No, you see, madam.
She has
See,
not been
You
examined.
see, the entire conviction, I mean, the entire case rests upon the evidence of PW8, the mother-in-law of the accused. Now you have got to prove your case that he is innocent, you have got to somehow discredit PW8, that's all.
Lordship may repeat my submission, but he will not be entitled to any benefit because the deceased died instantaneously, my lord,
Ah,
as a result of the blow.
correct,
So it was severe. It's on a vital part of the body,
correct.
lordship. So in that event of the matter, your lordship will uphold the judgment.
Is there any contradiction you could locate there? The statements
Lordship, PW8 statement.
that we have to find out. If you can show something on that, that will help you.
Sure.
May I come back next week, Lordship, any date?
She
I
needs
shall
preparation.
try.
Heard, Miss?
Be Barnali Chaudhary.
3,000 passes for, am I good?
Yes, Lordship.
Then am I good? Let's see, please. The case of the prosecution. No, the little transport had convicted the appellant on the basis of
Okay, that's good.
the evidence of PW8, who is the mother of the deceased and
Mother-in-law.
mother-in-law of the
Accused.
appellant. The PW8 had seen the appellant hitting the neck of the deceased with a dowel on 20/03/2007. The appellant then absconded and was arrested on 19/1/2018 that is after about 10 months. Miss, Miss P. Chowdhury, have acted to is granted a week's time to prepare herself better in this matter. List the matter on when
Take the date and let me know.
13, 14, and 13,
14th, Lord.
14,
14th,
Thursday.
or 13, maybe 13,
13th, Lord.
13, next week.
My problem.
May I please, my lord, in this case, for today only, I would like to seek an adjournment.
See, this is what happening.
No, my lord, only for today, my lord. My lord, may kindly fix this matter either on 8, 11, my lord, or 11 of this month, either on 8 or 11, my lord. I will do the hearing.
Sixth.
Huh?
Today is 5th.
Today is 5th,
Eight, no, not possible. I'm not there.
11 কি হয়? Monday.
Monday, my lord. Or on 18, my lord. Not 18. My lord, it is a case of murder. And case is basically based on the circumstantial evidence, my lord.
The PW6 is the eyewitness, I think.
No, she is not eyewitness, my lord.
Is that eyewitness?
But based on her testimony, my lord, conviction has been granted. Because my practical difficulty is that, my lord, there is another lady, her name is reflected in this cause list, P. Burwa. Basically, it is she brought me the case. My lord, she has some medical issues because she had a miscarriage.
Six has seen that accused going away from the place.
Yes.
Yes, my lord.
He was
Only from the
walking as a
back
man.
side, my back side, from the back
Then
side.
he was first moving his head and seriously.
My lord, that part is contradictory because on that particular aspect, the contradiction has been proved, my lord.
He was a painter working in the house of the victim.
Because that particular contradiction has been proved by the IO, my lord. I'm ready to argue, my lord, for today only I need some accommodation, my lord. I will definitely argue this matter without any delay.
On the prayer of the Prince Council, this is a matter after 2 weeks.
With your blessing.
Yes.
I'm the respondent husband lordship.
What is this matter about?
Respondent husband referred the application before the family court.
Time.
The review of the matter.
Consequently, we hold that the impugned judgment is not sustainable. Same is accordingly set aside. Respondents are directed to release the appellant immediately.
I can do.
The appellant is accordingly convicted under section 304 part 2. So 302 has been set aside.
Review of judgment.
Section 302 is not attracted. Accordingly, the appellants are convicted under section 304 part 2.
May please, my lord. My lord, item 83 and 84, my lord. That pardon matter. My lord, what has happened is that as submitted earlier, we're in negotiations with the railways. They are trying to find out a solution of how to distribute the money. So at least 10 days time may be given, my lord.
Why should I keep it partnered?
My lord, because my lord is acquainted with the facts of the case. That is the reason.
Are you all going to come to a compromise? Is it possible?
Yes, my lord, that is what the railways have taken the initiative. The railways have taken the initiative, my lord.
Where is Mr. H. Gupta? Who is the parent? Okay. Oh, maybe because 3 of
Man, only 10 days may be given. We will find out a solution. If a resolution is arrived at, then it is better for all the parties, madam.
Okay. So we'll say that a settlement is being attempted.
Attempted, madam.
Is that right?
My lord, I have no instruction from my client.
Please obtain instructions. What are you doing?
Our prayer in the IA application was to release the payment.
That is, Mr. Counsel.
And after passing your direction, I have already signed.
So we will fix the matter after 10 days. In the meantime, obtain instructions from your client as to whether any compromise can be made between the parties. Okay. You obtain instructions, so we'll direct you to obtain instructions. Mr. What is your name?
Hiranma Devnath, H. Devnath.
H. Devnath. Learned counsel for the
Applicant.
For the applicant. And Mr.
Arshad.
Sharma for the
But opposite party in the IA.
item number. Oh, that
It is 84, madam.
I am sorry.
Sharma for writ petitioner.
Writ petition.
For writ petition. Submit that the matter is being considered. The issue is being considered by the railways. And a settlement is sought to be arrived at. Mr. H. Devnath shall obtain instructions with regard to the above from the applicant. This is the matter on your date.
Obliged, madam. 83 and 84. Obliged, madam.
May I please, boss? The confirm order said, yesterday we have circulated the adjournment in respect to item number 85 and 86, Lordship. Due to
I'm going to release this.
Lordship, due to sudden medical emergency, Lordship.
You see,
His wife admitted due
no,
to
not that. Actually, I think your client should be happy also.
no, Lordship. Lordship, due to
You
his
see,
wife.
It's been lingering too long.
Lordship, we fixed a date after 2 weeks, Lordship, because he at Delhi, Lordship, due to his wife's urgent medical.
Completely, forgotten also what the issue.
Lordship,
It's been such a roller coaster ride.
he's
Very, very, very slow roller coaster ride.
he's supposed to argue this matter.
Not even a roller coaster, sorry, wrong phrase.
We have
already submitted written argument.
Lordship, Lordship may fix a date after 2 weeks, any date.
No, you see, I'll tell you one thing. You might have been. Then there is the issue of, I think, Mr. B.D. Das case also hasn't even started.
That is also Lordship a similar issue, Lordship. Lordship,
It's not even started.
not
Only
take-
one.
Lordship, it will complete within a half an hour, Lordship.
Yeah, no,
Respect
not
to his case, Lordship. After 2 weeks, any date, Lordship. He has assured that he will come and argue this.
Very difficult.
because his wife's some medical emergency, Lordship.
Maybe. I'm finding it very difficult. I've never had I've never
I know that.
heard matter like this.
I know that
First time.
from both sides some.
In the meantime, when one lawyer has given up,
Yes.
not been able to come also anymore.
Our
Last player, Lordship.
Huh?
Our part is over.
Your part is not over. The other thing is over. Then the next case is there also.
That will not take time, Lordship, because in this case, the issue is similar, Lordship. Only in respect of the lower court's order is there, Lordship, CGIT order is there.
To what effect? To what effect?
What effect that they have sought for regulation that was rejected also. Whether res judicata part is applicable in this case, that will we have to argue also. Only to that effect. Also.
In other
Others issues are same.
Very difficult.
On 26 or 28 also.
Now I want to release it and get it over with.
Lotso has already heard. So it is our not intention to avoid from your lordship, but due to his wife's some medical emergency. Lordship.
I don't even remember what the matter is.
Or otherwise, I will compete on that part. On next date, if anything happen, Lordship, I will come. I am aware about the facts, Lordship. So I can try.
Hmm? Last week also. No. Just give me the file. Let me see the last few orders.
But Lordship have already dictated the submission. Lordship. That is
Initial.
I think that
You see this June order on the pair of so who is suffering from back pain.
Yes.
Then you see again in June on the pair of so again.
That's why Lordship, next date, if anything happen, Lordship, I will have to Lordship. Only our reply part is here, Lordship.
Yeah, right. They give sometime in September.
First week of September, people Lordship, please.
Yeah, you're in no condition to ask. The last 3 adjournments have been made by you all.
Not petitioner, Lordship. I am for a respondent. Petitioner has sought adjournment.
On the paper adjournment made on behalf of the petitioners council. This is the matter on 11th.
Hello.
Ms. Gyan. There was initially 100 flood management project in the 11th plan, correct?
Right.
And these were approved by the Water Resource Department, Government of Assam, and the Ministry of Jal Shakti. Ministry of Jal Shakti had approved the 100. Correct?
Yes.
Where is your affidavit? Additional affidavit by 1 and 2 of it. Yes. Yes, it is there. Okay. I think that's there. That is there in your para 4 of your additional affidavit.
Details of FMP scheme.
Approved by Ministry. That's-
Ministry of Jal Shakti of India during 11 and 12th. plan.
Okay, so that's there.
Yes, sir.
Now, I think, anything else to discuss with regard to your case?
No, Bharat, nothing else. Only one thing is that may be observed in that order, Bharat. The remaining amount 40 lakhs, that is as per 100% work done by the department, Bharat. That is as per our record, Bharat, that is 10 lakh something. That is stated in our. Because 100% work has not completed in all that scheme, Bharat. So as.
So 100% work not completed.
Yes, Bharat.
That is, so if 100% of work was completed, then you would be liable to pay 40.
Yes, Bharat.
Correct?
Yes, yes,
But since if 100% of the work has not been completed,
yes,
and some of the schemes have been foreclosed,
yes.
that's why your liability as on date is only how much?
10.484.
10.84.
84.
Correct?
Not only foreclosed on
All the
100% physical damage.
okay.
Yes.
So for not only for the foreclosure, but for the uncompleted
Physical
verification.
verification. Ma'am.
So as per physical verification of the
Our
work,
liabilities,
of the work done,
yes,
of the work done, and also due to the foreclosure,
yes, madam.
your liability
Is
as on date is only 10.84
Yes.
and not 40.
not 40.
Not
That
40.
is our,
Correct.
yes,
But if this court holds that the foreclosure cannot be done
yes,
in respect of
retrospective.
those respectively, in respect of those contractors who have been given work orders prior to the foreclosure,
Yes, ma'am.
then your liability will go up.
Yes. That or for the foreclosed, madam.
Yes, foreclosure and for those, no, you see,
Those,
You see,
for
it-
those scheme, madam.
no, you see, one is foreclosed,
Yes.
foreclosed scheme. What? For foreclosed scheme, they'll have to pay them.
Yes, ma'am.
Then also for those for physical verifications.
Yes, madam.
Now, some persons have, wherever they have completed their work,
Yes, ma'am.
then you'll have to pay for that.
If for their work, they have to pay, madam, by the state government, but as a whole, if they don't complete the 100% work, madam, that should be verified by the state government, madam. Because in some work, they have done only 70%, 80%, not only for.
But you'll have to pay to the limit of your liability, you'll have to pay.
Because they have, that day they have filed one, state government has filed their affidavit, madam, they have stated one chart, madam. State government affidavit, madam.
Yes. Page 90. You mean this?
Yes, madam.
This
Yes,
annexure
please.
2.
Annexure 2, madam.
Yeah.
Kindly see physical progress 7, column 7, madam. In some scheme, madam, they completed only is 42 not only foreclosed, my lord, but some 100%, they have completed 100%, but some scheme only 72%, 89, then 100%, my lord, we will release all the amount where the 100% has already completed, my lord. And kindly see then, my lord, 15 number AS 102, only 50% work has completed, my lord. Page number 42.
Yes.
Serial number 15 AS 102, only 50% work done, my lord. Then P16 AS 103, only 82.5% completed. So we are liable to release the amount as per the physical progress, my lord. I'm not saying about the foreclosed, my lord, but on that, that is. And my lord, one thing is that there are total, all total 83 cases, my lord, in this lots, my lord. But some cases are not related to FMD scheme. That is, some is SDRF scheme. I have gone through the whole record, my lord. So some observation may be given in the order, my lord, that those who are related to only FMDP scheme.
FM?
FM, PPS,
FMP.
FMDAP,
FM?
BAP,
BAP.
BAP.
What is the full form?
Plant Management Border Area Program.
Flood Management
Border Area Program.
Border Area Program.
Yes.
So which cases are do not come under this?
That is my lord, WBC 3852 2023. These cases relate to some SDRF scheme. No,
Item the WTC?
I'll go to the my lord, list, my
Give me the
lord.
list.
Yes, my lord.
When can you give me the list?
Yes, my lord.
When?
Now, my lord. I'll tick mark on that.
Yeah.
Those
No,
who
no,
cannot.
you can tick mark here also.
3852.
Not with serial number?
Item number 31, my lord. Pradeep Kumar Agarwala.
Yes.
That case is related to some SDRF scheme, my lord.
SDRF.
SDRF, not
What is
FM.
SDRF?
SDRF, my lord, is state government scheme, sir.
What is the full form?
SDRF.
State disaster relief
Yeah,
fund.
state disaster.
State disaster.
Relief fund.
Relief.
That fund has to be released by the deputy to the revenue
Department.
department.
Department is.
To the deputy.
So this does not come under this.
Yes, my lord.
Under the 141 schemes, it does not come
No.
under this.
No.
SDRF is the payment made by the revenue
So
department.
this has to be taken out.
No.
Yes, ma'am.
This has to be segregated.
Then item number 29, my lord.
31, 29 also.
Yes, my lord.
The-
3849, that is also. These two, my lord, as per my list. Yes, ma'am. These two cases.
Are you sure?
Yes, ma'am. I'm sure. I have gone through that all the record of the courts, ma'am, not my record. Sir. But I have seen that is SDRF scheme, not related to this.
So where is Mr. DK Jain?
Okay, sir.
The council, because it is. Yes, Mr. The Water Resource Department. Arabda. Anything to say? Anything to add?
As your lordship has already decided, we are not.
Not decided. There is
We have
order.
already
That was.
dictated the order.
Huh?
Dictated the order of the
No,
last day.
that was just
What-
for my, for.
Yes, yes, yes. So the foreclosed scheme, as we have stated in our affidavit, the central government is not willing to pay the money, but
If they are not willing to pay, then it will be from the state
No,
executive.
no, so long as, so, you see,
Their share on the foreclosed part. We are not means asking for 100% funds.
to the amount that they are liable, they should pay.
Yes, yes, yes. That's it. And regarding the query, that AZ query, our officers have already been that letters. We have already written the same to the AZ office for that query.
Let us, just give me a copy.
Already, sir, AS 116, reply has already been sent to the AG and,
Just, 116 is not a problem. 116 has been released.
and
We don't want 116.
yes, and they told in the last hearing, the 11 point something is allowed.
Ah, yes.
Oh, sir, already reply has already been sent to the AG.
So they have released that, then you
Yes,
can
sir.
use that.
Yes, sir. Yes, sir. And regarding scheme code number 92, 93, 94, AG has fixed a inspection date on 8/8/2025.
93, 90, 92, 93.
Yeah, yes, sir. AS 92, 93 and 94.
They have fixed the inspection date.
Yes, yes, sir. So far report collected from executive engineer, Jorhat engineer, Jorhat.
When?
They decided to inspect 8/8/2025.
8/8/25.
Yes.
Okay. That means this Friday.
Yeah, yes, sir. And another skip 10 regarding
Three.
103.
Ah.
Sir, the reply has already been sent 24/5/2022.
24/5/22.
Yes, sir.
Okay, very good. So they have not taken a decision on that.
No, it's still not taken any decision.
Where is the letters you were supposed to produce?
The consolidated. But I'll reiterate, Manoj, so far as
Now this 63 lakhs.
Lord,
Now this pertains to which scheme?
Malad, when certain amounts have been disallowed in certain schemes, Malad, this is the consolidated amount which is disallowed. So that we have given the breakup, Malad. Otherwise, what has come from the other side that this is disallowed or what is today, as of today, Malad, out of 17 crores, subject to correction, Malad, almost 17 out of 17 crores, almost, Malad,
Out of 17.98, 17.35.
yes, out of 17.98 crores, almost 17.3 crores have been cleared. Malad.
Correct. So only 68 lakhs.
That request. This is my instruction. And I have placed that.
So you see, one thing that can be done is you give another letter giving the particulars of that 68 lakh
To the authorities, to the
to the chief engineer.
Lordship.
And then they will reply because now I do not know which pertains to which, how many documents.
Can I have half a minute, my lord? I think those letters are already there. Your lordship has a fatter
Yes, yes.
sticker bunch, my lord. Your lordship will kindly go to, there's a flag mark called Settlement of AOAS 93.
Yes. 92, 93, 94.
Yes. 93, 94, these are the letters, you know, we have sought for instruction.
No, but which letter is this?
This is one is
Specific letter.
23rd July 19.
Huh?
This is, my lord, yeah, the flag mark is Settlement of AOAS 93, yellow, pink flag. my lord.
No, it says 92, 93, 94. There is 90, just a minute. There is settlement of 93 there. You want for 93? Or which one?
92, 93, 94.
The first
One, 93, 94,
Yeah,
94, yes.
So here you have given the para, which para we have already settled, and for which para we need further documents.
So where does it say that?
Sir, this is, sir, para 4, sir. In the letter,
Part
part
two,
2B, para 4,
para
sir.
4.
You give this afresh to the chief engineer.
Okay, sir, no problem.
To decide. Let them reply within a month. That'll be safe. So the issue now boils down to only 68 lakh.
63.8.
63 lakhs. It has come down drastically.
The lordship has really churned up the matters.
Man.
That's good. Yeah, it's para 4, my lord, that the short note, 63 lakhs, 86,235. In the chart also, we have given what is required.
So earlier on the last date, you had spoken about there being a clarification required to be made with regard to 6.39 crores.
6.3, but
So that is not the correct figure now. So the correct figure is 68 lakhs.
63 lakhs.
63 lakhs.
62.5.
So that has to be decided. Okay, so we're getting somewhere. But what has happened to that 6.39 minus 63 crores, 63 lakhs? Where is that money? It has, now they can use it, or has it been used?
Yes, sir, we have issued the letter that this para's observation settled, sir. On production of that letter, they.
Yes, so the water resource department will have to work out.
Official communication, we have not received till date. Also, they have sent for extra for take. You have sent 23 July.
July 15.
24 when? Which month?
April 24.
2024.
24.
Then it should be with you.
And even with the department, we have done one AOC meeting also, audit committee meeting, so discussion on the basis of there are some paragraphs also been said. Minutes also we have.
I have seen here one day, but official communication, I have received the letter from the executive engineer. He told that para yet to withdraw. Para yet. to
You see
withdraw.
what I'll do? I'll give you my copy. You take
Okay.
this. You give him this.
I'll give him my instruction.
Yes, you give him that
Okay,
also.
sir, I
Take that also. Hmm. Only thing now is the,
okay, sir, remaining part we will submit the reply accordingly within.
yes, you do that. Now the issue is when this central government has taken a stand that their liability is limited only to this amount, to a certain amount, and you have given work orders beyond that amount, then what happens?
Actually, sir, several discussion has already happened. The scheme was sanctioned with a ambition that the scheme will go beyond 11 plus.
Will?
Beyond 11 plus. That is only the cost of works amount sanctioned for the 11 and 12 only. That much amount has been sanctioned. And the scheme will go beyond. And the planning commission has also extended the full estimated amount for investment. And that copy has already sent to the Jal Shakti, and several communication are also there.
But it has not gone beyond.
No, sir. But
Then what
no,
to do?
No response.
No response, then what to do? You all took a risk. It was a risk taken by you all that it will be carried over to the next plan.
They have earlier intimated any communication. Finally, they have intimated in 2025 only. Just in response to Abbasi sir DO letter. Earlier, so many communication with Jal Shakti and CWC, all communications are there. In your knowledge, in your knowledge, and yes, sir.
Let's go. Now you see the issue is this. The knowledge will be for everyone. Okay, but then the problem is that knowledge alone is not enough. You need the stamp of approval.
Yes.
That is not there. So for that now, what to do? You have to pay. You've got no choice but to pay. Otherwise, you pay and then you think of with the center if somehow you are able to find out some method or some mechanism.
Actually, in the DO letter, in response to Abbasi sir letter, DO letter, they have given a suggestion that a post factory approval is are given, and then in Annexation 9, they have stated that it is suggested that a fresh proposal in respect of the balance work may be prepared. That's what has already been executed, sir. If it is given in the sense of post facto approval, then it will be more easier to
show me where
to
What you mean about Annexation 9, page 67.
67.
Yes. Paragraph 3, last line.
67?
If you find
67.
No,
Oh yeah, filed by you.
no, filed by the Water Resources Department. Page 67, Annexation 9.
I don't have to.
No, this is our report.
Your affidavit. Your affidavit starts at 74. Additional affidavit.
Additional effect, yes.
Additional affidavit. Internal page, give me the internal page. Can it be 67? Then give them this.
Page number 69 of my.
117, okay.
Heart rate is halfway. It is suggested.
No, this I've seen. A fresh proposal for balance who may be prepared. But we have already given the work order for that.
Yes, yes, yes. Work has already been done. Completed,
Then can it be sent as a fresh proposal?
it is.
Not possible.
If the executed works, they have considered as a prospective approval, then it will be. Hello.
Okay. Nothing can be done, I guess, now. You'll have to somehow, state will have to somehow talk to the center and if you can get some assistance from them, well and good. Otherwise, it appears that you'll have to. Can't leave them in the lurch. So at the end of the day, your story that the center has not paid its share is not factually correct because you have taken it for granted that it will be eventually approved, but it was not approved. And that it has not gone beyond the 12th plan. Is it? Now, what is the plan now? What plan is it? What plan is going on?
No plan.
No plan.
FMBAP.
No plan. Well, okay. That's right.
One observation that every concept is center for releasing. That observation.
For releasing, how? They have to approve first.
Yes, for good better. Consultation may be done.
Okay, right. The stand taken by the AG bracket audit office, assigned is to the effect that though the additional affidavit filed by though annexure 6, Roman 6 of the additional affidavit filed by the respondents number 1 in WPC number 2303 of 2025 had disallowed no, not disallowed. The Accountant General bracket audit Assam had disallowed rupees 17.98 crore against 5 FMP scheme bracket scheme code AS 92, AS 93, AS 94, AS 103 and AS 104. Bracket close. Based on audit observation, the AG's office has now allowed the payment of bills in respect of AS 103 amounting to rupees 1159.76 lakhs. By way of a revised audit certificate dated 23/6/2020. In respect of the scheme code AS 92, AS 93 and AS 94. While issuing the audit certificate on 8/3/2019, the AG bracket audit office has disallowed rupees 637.87 lakhs based on audit observation. However, due to the replies received from the executive engineer, Jorhat Water Resource Division, Jorhat, on 31/5/2019 and 24/6/2024. The AG's office has already settled audit observations amounting to rupees 574 lakhs, which was initially disallowed. In respect of scheme code AS 104, the amount disallowed by the AG's office amounting to rupees 1.27 lakh was settled during audit committee meeting. And the same was communicated to the concerned water resource division on 25/4/25. Next one. The learned counsel for the AG's practice audit office submits that out of the remaining disallowed amount of rupees 6,39,13,562, the AG bracket audit office has settled / dropped audit observations involving rupees 5,75, 27,327, pertaining to the 4 scheme, that is AS 92, AS 93, AS 94, and AS 10. It submits that the Water Resource Department may take suitable action as deemed fit based on the settlement of the audit observation, which has been intimated to the Water Resource division. However, there is a balance amount of rupees 63,86,235, which could not be settled for want of documents / replies from the Water Resource Department, Government of Assam. Correct?
And the same was intimated to the division.
Next. The settlement of the audit observations made by the accountant general bracket audit bracket office for rupees 63,86,235 was intimated to the department by documents which have been produced today before this. The said documents have apparently not been given to the office of the chief engineer or the water resource department. Accordingly, this could direct the AG audit office to provide copies of the documents which are copies of the document for settlement of rupees 60, the balance 63,86,235. When? Within the course of the day. Huh?
Will give me 2 days.
Within 2 days from today. The office of the chief engineer, water resource department, government of Assam, and thereafter submit replies to the AG audit office at the earliest, which should enable the accountant general's office to take a decision. And give a copy of the decision to. No, don't say it. I give it. The decision. Then it will be completed within a period of 1 month. 1 month from. Okay, next. Yes, right. The stand of the central government is that though the liability of the central government for the 17th scheme mentioned above is limited to rupees 172.46 crores out of the approved fund requirement of 191.68 crores. The actual balance payment to be made by the central government is rupees 10.48 crores. The- 84. In as much as a number of schemes, a number of the 17 schemes have not been completed. As such, the central share at the rate of 90-10 or 80-20.
Now we keep.
As at the central share payable would depend upon the actual work done. In respect of all the 17 schemes, including the foreclosed. The learned, no, the central government has also, the central government stand is that as the present case pertains to the scheme pertaining to flood management border area program, bracket FMBAP. The issue to be decided, no, the contractual, the payment of, the issue of payment of contractual fee can only relate to FMBMP scheme. However, WPC 3849 of 23 and 3852 of 23 do not pertain to the FMBAP scheme, part 2. The State Disaster Relief Fund Scheme, bracket SDR. As such, the above two writ petition cannot be covered by the decision to be made in the present batch of writ petition. Next, then, witness Tara, you have. On considering the fact that the payment of non-contractual due in the present batch of writ petition pertains to the flood management border area program, FMBAP. WPC 3849/2023 and 3852/2020. Just give me this file. 29 and 31. Which what have I said? Which pertains to the state disaster relief fund bracket SDRF. The set to rate petition cannot be decided by this month. The two rate petitions are accordingly taken out from this batch of rate petition and listed separately before the concerned. This is separate before the concerned court. Before the appropriate. Court. Madam, how do you say, Gayan, how do you say that this, item 31 is a SDRF scheme? Huh?
Number 7.
Yes. Okay, okay, yes, okay. Okay. I'll. Right. Okay. Okay, okay. Anything to be stated?
No.
You're not finished?
No, I am finished. But if you not to point that care of the federal government, the two of these 10.4, then the foreclosure scheme will be left. That I want to. Oh,
No, wherever the work orders are issued,
yes.
if it's prior to the foreclosure, where the bills have been made, then they should be. But it should be provided, it should limit itself to the amount that they have limited themselves. So you see, the thing is that, has there been, you see, the problem is, your affidavit shows that the progress of the work is not complete. Without the So depending upon the amount of work done, then they limit themselves to that amount only.
Yes, but these works makes the payment are being completed because in some of the schemes, the state government has, now the state government has started paying from their own, the central share of.
Have to. You see, wherever, like say in a particular scheme, say AS 95 or so, 94 or so. Supposing the amount of work done is say 50%, the entire. Now supposing they were supposed to give say 90 crore. Then limit will come down to 50 crore or 45 crore.
50%.
50%. Only thing is that, now the thing is that if you have completed 100% or more than 50%, then the share that they have to pay, they will pay.
So in AS 91, that is serial number 2 of Annex 2, the scheme has been completed 100%.
All those 100% they have to be. But where there is say 50%, you can't expect them to pay 100%.
As per their share.
Because I've been producing loose documents a lot. They will make part of the records.
It's too many, let it be ready.
That will be followed. 2 days later and that bunch, yes. This is our total standard.
There you go. That's right. It is needless to add that the payment fund by the federal government would be limited. The progress of work that completed work done in respect of each. And if work orders has been issued prior to 2019, the payment of the work already done by the petitioner would have to be borne by the state and center in terms of their respective share. While keeping in the overall progress like percentage of work done in each in this. Anything else? From the petitioner, anything?
The state government report was for.
I have mentioned somewhere, I'm going to, I've mentioned somewhere that y'all can have a relook. I've mentioned somewhere that you can have a relook and find a mechanical happen. Besides that, what can we do? Only one thing is that, what about this, you said that, due to the 2016 flood and damages caused by the upstream channel flow at Tapar Bita area.
116.
Tapar Bita,
Number 116, that is still,
under AS 116.
yes,
116, that,
that one, that is 12 plan scheme, sir.
huh?
12 plan scheme, not within the 17 numbers of it.
Okay, then one more thing, you just write. A perusal of the chart provided by the Water Resource Department, Government of Assam. In respect of the fund requirement for the 17 FMP scheme taken up during the 11th plan. Comma. As no, which is relatable to the administrative approval cost. This chart is not correct also there. It is as per the A. A has not been accepted.
There is no issue of a 116, it is INC.
No, I'm not talking about 116.
Yes.
I'm talking about the 17 scheme.
Yes,
That chart you have given me. This is made as per the A.
yes, yeah.
And A is for 346 or 341, whatever.
Because A has been approved by the planning commission, that's why.
Like, why you go back to the same thing, running around and
That's
around?
why I doesn't want to talk to your law saying that.
What do I say? Shows the various stages of physical progress of each of the 17 schemes. However, it has to be noted that the said percentage of physical progress with regard to the said 17 scheme may not be accurate in as much as the Government of India has approved the fund requirement of the 17 scheme, not in terms of the administrative approval or amount of rupees 341.453 crore, but to the but to the amount of rupees 191.68. Yes, madam, you Ready to burst, that is, yes.
No, my lord, if your permit me, then I want to raise one.
Yes, yes.
point. My lord, earlier also you give us you gave us one sons for resolving the matter, means in between the central government and state government. In your last order, my lord, you gave us the science of resolving or discussion. So I think at this point, there is nothing
To discuss.
to discuss. Anything else? As Secretary Madam also cleared all about this, whatever left in central government. So it's, there should not, means, my lord, it is no mechanism is going on in this regard.
Nothing is going to happen.
Going to happen.
They are going to take the stand that, look, High Court has given us a handle to relook the matter, so we are taking steps and they're going to delay.
Already have done lots of.
Let them just relook. We are not forcing them to give the.
No, but then there is no bar. Even if I don't give you that handle, there is no bar for you to relook.
But if they put already, like, then it will be easier for us. That is just a request from the Water Resources Department.
It will not means come out the final result then.
Because one thing that might delay the payment also. They'll use it as an excuse.
No, we will not delay the payment, Lordship, because payment will be made as per the fund available with the Water Resource Department. And on the fund received from the ground.
We did.
If your Lordship add that line, we can approach the Ministry of Jal Shakti. This line will not found the water ground, neither the Brahmaputra board nor the Ministry of Jal Shakti.
But it might harm the petitioners.
Lordship, how can it be?
Delay.
No, because Water Resource Department will pay from their own pocket as per the availability of fund.
As per-
May come in another direction. A petitioner, then the state government may reply petitioner that you have to find, as per court order, we have to find out the mechanism between central and state. Mechanism is not find out. So case is not be completed means.
On that.
That is my request.
Person will also play, and you can.
Yeah.
Water resource.
Member of Senior Joint Commissioner, FMBAP, he also personally attended that meeting on that day.
And you all couldn't agree. You all didn't talk to each other.
They have talked.
There, state government also there, and
No, they do find.
no solution.
But sir, no
Fine,
consensus has been made here. They have prepared on-sitedly the money. Not signed by the.
So nothing
Secretary
is
of
left,
Operations.
so nothing is left to find out between this.
Okay, let me see. Yes,
The liability is already admitted, Lordship. You are not asking for more. Whatever they admitted, the liability, according to the liability statement, Lordship,
correct.
we may be paid. It's,
No, only thing is that,
we already
you see
received
the-
of order, we got the liability statement also we have. They admitted,
no, now the story has come out, no? Now the story has come out. So the story is this, that they made a plan for 341 crore.
Lordship.
And center agreed only to 191 crore. However, they've given work orders for 341 crore. And now they're saying that
It's
center
between
hasn't
them,
given its
Lordship. It's
share.
got nothing to do with me, Lordship.
No.
We invested our,
Agree, but you've got to understand. I'm not on that.
whatever they're liable.
That's all. So now at least we know the story because they were
That's it.
saying that the center has not given its share. But actually the center
The
has
story
given
is-
its share. It's maybe a few 10 crores are not given. That has to be given.
Lordship.
That 10 crores will have to, actually just type one thing. The admission made by Miss Pregan, Miss Egan, Leonard CGC that the arrear payment of rupees 10.84 crores is still to be paid. Requires the central government to immediately release the said amount to the state government. So the same should be done within a period of.
It depends upon the proposal of the state government.
To be done within a period of
All other 11.
2 months from the date of the proposal and verification made by the state government with regard to the said concerned schemes.
Received at the central.
Correct. Proposal sent and, okay, whatever I said, proposal and verification received by the proposal and verification of the work done, which is received by the central government. Yeah. We received by whom? Brahmaputra board. Received by the Brahmaputra board. By the Brahmaputra. Huh? What about audit clearance? That is under that 10.84 is within that 11 point thing. 11 point this, huh? Then, no, that 10.84 is for which scheme? For those schemes. That too, we cannot, the nitty-gritty we cannot. Okay, then we'll pass the order.
Such a time frame may be given.
Is 116? What? Now they are saying it's not, it's.
That's a foreclosure scheme. They are now saying that the foreclosure scheme, they will not, do the scheme which are not 100% will not, they will not leave. And although your lordship had
Only
indicated that
35%.
we release their percentage of share based on the scheme, means foreclosure scheme.
That's a 12 plan scheme, sir, 116. Proposal has already 2 times handed by the Brahmaputra board to the Jal Shakti.
Just right, one more point. It is also clarified that the central share for all the foreclosure schemes would have to be paid if the work order had been issued prior to the foreclosure of the scheme. However, as stated earlier, the share payable by the center would be limited in terms of the share ratio made by the central and state government in terms of the foreclosed. So whatever share ratio is there, and as long as the work order is there for that, and if it comes within your the amount that you have admitted, you have undertaken to give, you have got to pay that.
In case of foreclosure scheme, if suppose it is completed only 35% or 30%, then central share, for this only this, another guideline of FMDAP, which are, those scheme has been completed before 2019, but they have submitted the bills now at present. If the bills are submitted.
You see, for all those, for all the work that has been done prior to the foreclosure, or all the work done up till that foreclosure, you have got to pay everything. But has the work been done after the foreclosure?
No.
No. So till the date of the foreclosure, everything, the bills that have to be cleared have to be cleared.
As per physical focus.
So just get it. The bills, the contractual bill would have to be paid as per the work done and on the date of the foreclosure. So I'll just pass the order now. That's it. Head sensor. Hearing concluded. Order reserved. Just few days, by next week, because really busy.
Time frame may be given.
Time frame,
I'm paying for 8 months, like.
Lordship, that
is because the water resource department will have to attend to fund, your lordship is also aware. Now. yeah, Because if lordship decide which the time frame is short period, then again the petitioner will have to approach this court by filing contempt. So
I think even if we give 8 months, it will still be.
Lordship.
Still, we can.
6 months may be given, Lordship.
Huh?
6 months may be given,
Lordship,
Lordship.
at least we can release the payment, that's why I'm just paying. Because 6 months and 8 months doesn't make much difference. Lordship.
That's why, Lordship.
I'm just paying the full amount.
Okay, just right. The documents which have been submitted today by the Accountant General's office are marked as, are made a part of the report and marked as an X collectively and Y collectively. Huh? No, this is a affidavit.
Our equity.
Lord, I've given the list of officers. I've
Huh?
the list of officers who are present, that may be recorded.
No, not in the pen order. Huh? We can, but I don't have time, that's the thing, it doesn't look good. I'll pass, I don't have time to, it'll take some time to,
Lordship.
2-3 days. It doesn't look good to, say dispose of and it'll take some time. By next week it'll come out.
This matter is coming up again.
No,
No,
the order. I can put it for, I'm reserved or I can say disposed of. Let it be, which is reserved, order reserved.
Lordship.
The officer's name may be recorded.
Huh?
Officer.
No, not in.
All right.
Public.